Okay, guys, welcome back. This is your lesson for Thursday, April 2nd. A couple of quick notes before we get started. If you've not completed the reading quiz from yesterday, make sure you go ahead and get that finished. I intend to close that at the end of the day today. So if you haven't done it already, please make sure you do. Second announcement, there's going to be a quiz on the first half of Unit 6, the legislative branch, tomorrow on Friday, April 3rd. If you have any questions or concerns about that, please send me an email, and I'll do what I can to try to help you with those as well. So that being said, let's dive into the second half of Unit 6, talking about the judicial branch. First thing that we need to do is we need to make sure, again, that we understand the difference between criminal law and civil law. In criminal law and criminal cases, the government is going to be involved in some way, shape, or form, right? You're either going to be the state versus somebody, so Ohio versus Mr. Brandewie, or the federal government, the United States versus whoever. That is not necessarily the case in a civil case. The government can be involved in civil cases, but they don't have to be. It can be one party suing another. So if you think about the McDonald's coffee case where, somebody spilled coffee on themselves from McDonald's. It didn't say caution hot on the outside. That is a person suing a company that is not involving the government in any way, shape, or form. So that is obviously a civil case. A punishment in a civil case is going to involve typically some sort of financial penalty, whereas in a criminal case, it could, and sometimes, or in many cases, does involve some level of time incarcerated or going to jail, going to prison, whatever. The biggest difference that we need to make sure we keep focused on as we proceed here is the difference in the threshold for a ruling, for a guilty verdict, so to speak. In a criminal case, you need a unanimous verdict, and the jury has to be sure beyond a reasonable doubt. Whereas in a civil case, they just need to believe that there is a preponderance of evidence to suggest that somebody is responsible or that somebody is liable. So in a civil case, the McDonald's case again being the best example, the jury said that there was a preponderance of evidence that McDonald's was responsible for this person burning themselves. Right? In a criminal case, there would have to be a unanimous verdict that beyond a reasonable doubt, so-and-so is guilty of the crime they've been accused of. So looking at a few examples here, kind of, again, differentiating between criminal and civil law, a couple that is dividing up their Beanie Babies under the supervision of a judge is obviously a civil case, not a criminal case. Nobody's broke the law here, although having that many Beanie Babies should in fact be a violation of some sort of federal code. But again, it brings us back to this really, I think, useful and really demonstrative chart that kind of talks about the difference in guilt or liability in a criminal case versus that of a civil case. In any case, there are going to be what we call litigants. There's going to be a plaintiff and there's going to be a defendant. The plaintiff is the person that is bringing the suit to court, right? So in a civil case, like the one we see here, Kate is the one that is bringing the suit to court. She's the person that is suing someone else, so she is the plaintiff. In this particular case, this person right here, Jonathan Coward, he is in fact the defendant. He is the one being sued because, well, he's being accused of killing Kate's cat. He denies it, so he is the defendant in this particular case. Obviously, this one and all of the court television that you see, Judge Judy, Judge Joe Brown, whoever it might be, that's civil law. In the Brown v. Board of Education, however, our example, the Brown family is the plaintiff. The Topeka Board of Education, Sparta Township, is the defendant, and obviously that is a example of criminal law, where the Brown family is in fact suing the Board of Education, saying that they are in fact violating the Constitution. OJ versus California, the state of California versus OJ Simpson, a good example of criminal law. Class action lawsuits in almost all cases are civil cases. And then amicus curiae briefs. Amicus curiae briefs, again, are an example of an interest group stepping in and on behalf of one of the litigants. So if you're talking about Obergefell v. Hodges, in which we have a whole boatload of amicus curiae briefs submitted, or if you're looking at NFIB versus Sibelius, where there's, I think, like 140 amicus curiae briefs submitted to the court. Again, amicus curiae briefs stepping in on one side or stepping in for one of the litigants. Both of those cases are excuse me, both of those cases, both the Obergefell case and the NFIB versus Sibelius case, are in fact civil cases. So before we can really move too much further, we need to start talking about the structure of the court system. So only 2% of the courts across the country are federal courts. 98% of them are state courts. So there really isn't a ton that ends up in federal court in the first place. And maybe most shockingly, when we look at the Constitution, there's really only one court that is specifically designated in the Constitution. There's only one that it actually directly creates, and that being the Supreme Court, the highest court in the federal system. That's the only one called for by the Constitution. The other federal courts are kind of the creation of Congress. The Constitution lets Congress kind of decide what they want to do as far as lower courts are concerned, and they really get further guidance about how to create or what kind of lower court system to create with the Judiciary Act of 1789. So we'll work our way through the federal court system here fairly quickly, because we'll definitely be revisiting throughout the course of the rest of the unit. But district courts are pretty typical in the way that they look, in that you can see where the judge sits there at the front. You can see where the jury sits over on the left-hand side of the picture there. You can see where the defendant is going to sit at the long table right here. And then you're going to see the prosecution, or the plaintiff, if you will, sitting over here on this side. So their jurisdiction is going to vary. They have jurisdiction over all kinds of different things, all kinds of different cases in district courts. You're going to have jurisdiction on criminal cases of any federal crime that takes place in their district. They're going to have jurisdiction on civil cases that involve federal law. They're going to have jurisdiction on civil cases that take place between citizens of multiple states. So even if it's a violation of Ohio law, if the lawsuit is between a person in Ohio and a person in Indiana, that is going to go to a district court, to a federal district court, not a state court. Bankruptcy proceedings and immigration cases are really the other two big ones that end up in district court. But again, they hear both civil and criminal cases in district court, and you can find them all across the country. We have 91 district courts across the country. Every state has at least one, including Washington, D.C. Several states have more than one. And you can see kind of how those districts are broken down, right? So we are in District 6. The nearest district court for us is in Dayton, the Northern District up there on the top, the Southern District there on the bottom of the map in Ohio, and obviously those districts are split yet again into a Western, Eastern in the north, and a Western and Eastern in the south. So our closest district court is in Dayton. There is a picture for you. A district attorney is going to be the person that prosecutes or is responsible for kind of leading the case for the state in a district court, or for the federal government in a district court. To get the job as a district attorney, you are appointed to that position. So you're not necessarily just given it and keep it for an unending amount of time, but it also isn't an elected position either. So typically what you see is that when one president leaves office and a new president or a new party takes office, you see a pretty big turnover in district attorneys. States have district attorneys too, so this position does exist at a state court level as well, but again, those typically move in and out as leadership changes. Federal appeals courts, the next level of the federal court system, 75% of the time, they hear an appeal. So if the district court makes a ruling, say they find such and such a person guilty of a crime, and that person that was found guilty wants to appeal the decision. When they appeal the decision, it means that it moves up a level. It goes to the Court of Appeals. And what you'll notice immediately in looking at this is that a Court of Appeals looks a lot different than a district court, or looks a lot different than probably the typical picture of what you think a a courtroom looks like. The reason being is because you don't have a court of appeals hearing in front of a jury. It's going to be all of the parties involved except for a jury. Instead, basically what the Court of Appeals is going to do is they're going to listen to the facts of the case, and then the three judge panel that sits up here at the front of the courtroom is going to make a determination. Was the original ruling, the ruling from the district court, was it appropriate? If they determine that it was, your appeal is denied, and that's that. If they determine that the original ruling was not appropriate, that the district court got it wrong, then basically it throws everything back up into the wind, and it's okay. We have to retry the case and make sure that we get the right verdict here. But 75% of the time that an appeals court hears a case, they deny the appeal. They say, nope, the district court got it correct. They really don't like going back and telling the district court that, hey, you guys got it wrong. Appellate jurisdiction is going to be higher than original jurisdiction, and you can find circuit courts in one of 11 different circuits across the country. So again, as we move up the food chain, there are fewer and fewer of them. And then obviously the top of the food chain is the Supreme Court of the United States, or SCOTUS, the abbreviation you've all seen me use all year long. But the Supreme Court of the United States is going to be the top of the federal court system. And obviously we have 9 Supreme Court justices. We have 9 Supreme Court justices because we need to have a majority, or we need to be able to get to a majority on a decision. We don't want any ties. We don't want any 4-4 ties. We want a 5-4 decision or a 6-3 decision as much as we can get it. And we'll get more into the conversation about why 9 instead of maybe 11 or 13 or whatever as we proceed here. That should be something that pops up in a reading assignment that you have coming on Monday. So how do we decide which cases the Supreme Court actually gets to hear? Well, they actually decide for themselves, believe it or not. There's about 8,000 requests per year for the Supreme Court to hear a case, and typically they hear about 80 cases a year. That's an average workload for the Supreme Court in the course of one calendar year. They all have clerks, basically interns that work for them, that do a lot of the screening, and basically they get to just decide on the cream of the crop. Okay, yes, we want to hear this one. No, we don't want to hear this one, so on and so forth. In order for the Supreme Court to hear a case, 4 of the 9 Supreme Court justices have to agree to hear it. If you don't get to 4 of the 9, the Supreme Court is not going to hear your case. Why is the rule of 4 instead of the rule of 5? Why don't we make it get to a majority? Well, we don't want a majority of the court to say no based on political reasons, right? If we had five liberal leaning justices and 4 conservative leaning justices, you wouldn't want the 4 conservative leaning justices to never get to really have any say in what kinds of court cases are heard. Similarly, if you had 5 conservative justices and 4 liberal-leaning justices, you would not want the 4 liberal-leaning justices to have 0 say in what kinds of cases are heard in front of the court. Typically, Supreme Court justices have been very, very picky and very, very thorough in deciding, okay, we can only hear X amount of cases a year. We can't hear every single case that we get petitioned to try. They tend to be very thorough. They tend to be very picky in making sure that the cases they hear are going to be the ones that are most meaningful, the ones that are going to have the impact on the largest number of people, and the ones that are going to be the most precedent setting moving forward. Most of their cases are criminal. They don't hear a ton of civil cases in the Supreme Court. They do hear some, but it's very, very, very few. Most of the cases that they hear are going to involve some sort of criminal case in which the law is in question. So now that we've ripped through kind of the structure of the federal court system, most states have their court systems, their state court systems set up in the same fashion. We do here in the state of Ohio. We have county municipal courts. Then we have an Ohio appeals court with a 3-judge panel, much like the federal appeals court or the circuit courts do. And then we have a Supreme Court as well. We have 7 judges, whereas the U.S. Supreme Court has 9, but again, the structure is largely the same. So we'll continue talking about the federal court system and the judicial branch as a whole over the course of the next week or so. If you have any questions, please send me an email or get a hold of me. I hope you guys are doing well, and I will talk to you tomorrow.